offenders who know the justice system, how it works, they continuously get out on bail conditions.
It's not a matter of race. It's a matter of public safety.
There's no way that we can continuously monitor those who are out on bail.
The country is saying there needs to be reform.
Hello, everybody. It's MP Larry Brock, yet again with another community service video, this time looking at and discussing the Liberal government's Bill C-48, their version of bail reform. I am so pleased to be here on the Six Nations territory at the Six Nations Police Service, joined by the Chief of Police of Six Nations, Chief Darrel Montour. Also pleased to have with me a good friend of mine from my Crown Attorney days, the Acting Deputy Chief Tim Bomberry. Thank you, gentlemen, for the opportunity of meeting with you and discussing C-48. So maybe, Chief, I'll turn it to you. You've had an opportunity, because I forwarded on to you the draft bill itself. I can inform you that the bill has only gone through first reading in the House of Commons. There has not been a significant debate on it. You can be rest assured I'll be speaking to it probably at least 10 minutes, if not 20 minutes worth of debate, answering as many questions in the House that they throw at me. But that likely will not take place until sometime in the fall. In the meantime, we still have a problem on our streets. We certainly have a problem here on the Six Nations territory, and that problem has been shared by police chiefs from across this country, by premiers across this country, by police associations across this country, that the government is not doing enough to hold serious violent offenders accountable and in jail where they belong. That there is more of an emphasis on the rights of the accused at the expense of the victims and the community. So I'll turn it over to you, Chief, at this point. What's your initial reaction to the content of Bill C-48?
Upon reading it, and I know I seen it in draft form, it came out a while ago too, and then it was forwarded to me by your assistants at your office there. It doesn't change anything. And there's more reverse onus charges, yes, for serious offenses, but those serious offenses already have a reverse onus caption in there for bail itself. And to me, that's not going to change anything. What needs to change is, why are these serious repeat offenders being released? They're already charged with reverse onus offenses already. But in my opinion, and just speaking from experience having policed here for the last 31 years, is that there needs to be something in place that protects the community and the victim.
All right, so maybe the next question could be answered by one of the two of you. Could you educate very simply? We always hear these terms about reverse onus, and that this is going to be the answer to all the problems that communities are facing. Can you provide our audience with just a general understanding and a description from a policing perspective as to what crown onus and what reverse onus does, and the applicability of these onuses on the day-to-day operations in bail court?
For the reverse onus, that falls on the accused to prove why he or she should be released on various charges, whatever they may be. And the crown onus is basically the police working with the Crown's office saying, this is why this person should not be let out, based on these charges, the seriousness of it, how it's affected the victim, the victim's families, the community itself, because we're hired here to protect this community. And it's pretty hard to do and frustrating at times when there's a repeat offender out there who's committed serious offenses who continuously gets released. I go back to the auto theft issue we had here many years ago on the territory. Project Shutdown was very successful in enhancing the community safety from all of the high-speed pursuits and the way people drove through the community here during any given time of the day, especially during when the school buses are on the roadway. So for the reverse onus, the accused person basically has to say, why should I get out? This is why I should get out. And another issue is the Ledoux factor. And I've been advocating for the victims ever since the Ledoux case law came out. Don't get me wrong, it works in situations where the offender needs that assistance from whatever charges they're going through. There's intergenerational trauma that they've faced, causing them to have addiction issues, trust issues, obviously, and Ledoux in certain cases does work. But for those offenders who know the justice system, how it works, the repeat offenses that they continually do, they continuously get out on bail conditions that they breach anyway.
Okay. I'm going to turn the next question to you, Acting Chief Bomberry. So we just heard from the chief to describe the various different onuses, the crown onus, the reverse onus, how the reverse onus is emphasized in Bill C-48. Can you now educate the viewership, and particularly your community? The narrative that our Attorney General, the chief legal officer in this country, the narrative he is sharing with Canadians is that basically this is groundbreaking territory. This is going to make it more harder and more difficult for those serious violent offenders to obtain bail by increasing the number of reverse onus provisions to various charges. In his belief, this will make our community safer and restore the confidence that the public has been losing in our criminal justice system. What do you say to that?
I think who needs to be looking at the reverse onus aspect are the judges that are sitting and the justices that are presiding over these bail hearings. And they have to realize who they need to protect more so. I think in this, like you said, this is where you're looking at the rights of the accused versus the rights of the victim. To me, like, we police in our own community. Okay. So it's not for us, it's not a matter of race. It's not. It's a matter of public safety, of our community safety. A lot of times, our accused parties may be family to the victims themselves, and they're afraid. And we look into that, and we have to address that, and we try to address it as strenuously as we can in our paperwork to say they need to stay in custody. This person needs to be in custody.
Let me ask this question as bluntly as I can. Will a reverse onus provision and more reverse onus provisions keep the Six Nations community and other communities across this country safe from serious violent offenders?
No.
Why?
Those charged with those reverse onus offenses need to be held in custody to protect the community. They cannot commit further offenses if they're locked up and away from the community itself. I go back to the Purcell shooting. Mr. McKenzie was out on bail for a number of serious offenses, assault, police, firearms offenses. He was to reside here in the community. And he cuts his ankle bracelet off. He's gone into the wind. We only have 38 officers here policing this community. At any given time, we could have 3, sometimes 2 officers working uniform. There's no way that we can continuously monitor those who are out on bail. We don't have the manpower or the time.
So simply increasing the number, if I'm hearing both of you correctly, simply increasing the number of reverse onus charges in the criminal code will not equate to more individuals being detained in bail court. Is that correct? Is that what I'm hearing?
That's correct. I don't think it will.
I mean, you already have. Like you said, people are out on cognizance of bail conditions all the time, and they still reoffend.
Yeah.
Okay.
And they get picked up, and they get another.
Yeah.
So do you feel, gentlemen, that the broader issue that really needs to be addressed by government is to give the judges and the justices of the peace, and particularly the justices of the peace who do the lion's share of adjudicating over bail hearings from coast to coast to coast. Do you think the more appropriate approach is to give them the proper tools where they can significantly have at their disposal grounds by which they can hold these offenders accountable? We all know that there are 3 grounds in the criminal code as spelled out in section 515. The primary ground, will the person show up for court? The secondary grounds, the protection and safety of the community, etc., and the substantial likelihood that the offender, if released, would commit another criminal offense, and the tertiary ground, all about the confidence that the public should have in the criminal justice system. Do you think the government should arm our justices with those tools so that when they are faced with a serious violent offender, that they could utilize the secondary grounds and the tertiary grounds more effective to hold these offenders accountable and to keep our community safer? Is that the better approach?
Yes. It's common sense.
Yes.
Because, again, I go back to, like, I know I keep bringing this up, but I'm very passionate about this. Like Tim says, we're here to protect this community. We grew up here. Our families are here. Our friends are here. We have colleagues here, like Tim's son is an officer with the service. My nephew is we want to ensure that there's a great future for them going forward too. And we need to protect this community as best as we can. Because at times, I'm not going to lie, it's very frustrating for the work that goes into an investigation. You charge, arrest the offender. The next thing you know, they're released again. Because, yes, they're Indigenous. Yes, sometimes some people do deserve to be released. Other times, they do not, because they're a threat to the safety of this community.
And what is the community at large? What do they think about our criminal justice system?
I hear it all the time. Like, people are very frustrated with it because there's nothing worse to deterrent. And speaking from experience dealing with one of our officers, former officers here, his son was a victim of a homicide. And that just wrapped up in the Cuba courts. Yes, there was a conviction, but then, okay, upon sentence, what happens now? We're going to be faced with a pre-sentence report and Gladue factors for that accused person. And my thing is, where's the advocacy for the victims and the victim's family?
Correct. Well, gentlemen, any final thoughts before we wrap things up?
Well, like you said, obviously the country is saying there needs to be reform, right? Yeah. And I know we have, everybody wants a safe community. It doesn't matter where you live, big community, small community, everybody wants to be safe and secure and make sure their family members are safe and your friends are safe, right? And if we as the police, the Crown attorneys, everybody, that's pretty much our job to ensure.
Yeah. Final words, Chief?
My thing is, the government needs to start listening to the people. It's great that these people do these studies and do research and think that they know that this will work. Get out on the streets and talk to people.
There often is, I often find, a large disconnect between an academic theory when it comes to keeping the community safe and what's actually happening on the streets. You two gentlemen have lived the reality of on these streets, okay, for several decades. So I've given you the final word. My final word is this. Bill C-48 is a small, and I repeat the words, small, incremental step towards the broader issue of keeping our community safe. It will not be the answer to all of the concerns that police chiefs from across this country and premiers have been asking for. It is a small step, but much more work needs to be done to ensure that serious, violent offenders do not receive bail and that we can restore confidence and safety in our communities. This is MP Larry Brock. Talk to you again. Thank you.